After speaking with counsel at the bench, we are going to take matters out of order. Ms. Wong, would you please come forward? Right up here to be sworn.
Raise your right hand. You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do. Thank you.
Please walk right around here and take a seat. Mr. Nermy, you may proceed.
Thank you, Your Honor. Good morning, Ms. Wong.
Morning.
Could you state your name for the record, please?
Grace Wong,
And Ms. Wong, for whom are you employed?
Turner Broadcasting.
And in your, may we approach, Your Honor?
Mr. Nermy, why don't you try again and see if you continue to get the feedback.
Okay. Ms. Wong, in case it wasn't clear, for whom are you employed?
I'm employed by Turner Broadcasting.
Okay. And in your capacity in working for Turner Broadcasting, have you been covered? Well, let me ask you this before I do that. What is your job title with Turner Broadcasting?
Senior Field Producer.
Okay. And as your job capacity as senior field producer, have you been covering the trial proceedings, State versus Jodi Arias?
Yes, I have.
Okay. And when did you begin your coverage of these proceedings?
I'm not exactly sure of the exact date, but it was the first day of jury selection.
Okay. So you've been here since jury selection and nearly every day at the trial, is that correct?
Correct.
Okay. And in your capacity covering this trial, you've been in the gallery most of these days, is that correct?
Yes.
And making observations of the trial to report on those?
Yes.
Okay. And in that regard, are you familiar with the jurors, at least in terms of facial recognition?
I'm familiar with the jurors that I can see from where I sit.
Okay. In terms of the jurors you can see from where you sit, do you know the numbers of those jurors that you're able to see?
Most of them, yes.
Okay, could you recite those for us?
Juror number 1, juror number 2, juror number 3, juror number 4, juror number 5, juror number 9, juror number 18, juror number 17. Most of the jurors, but, you know, I'm not exactly sure. I mean, if you gave me a test to match, I think those are the numbers that match the faces that I remember.
Okay. You don't think, you said most of them after you cited off a number, so are there other numbers that you recognize, or?
Well, I know them by face,
Okay.
so that's how I remember them. But you know, now that I'm recalling their numbers, you know, I'd have to sort of see their face again.
Okay. Are there certain jurors you feel like you're blocked from seeing? Is that what you're telling us?
Correct.
Okay.
Correct.
And do you know where those jurors are seated?
Yes, most of them.
Where are they seated, the ones you cannot see?
The juror number 10.
Okay. So juror number 10 is really the only one you may not recognize by face. Is that correct?
Yeah, and juror number and juror number 1, I'm not exactly sure.
Okay. Now, Ms. Wong, prior to these proceedings, it's my understanding that you got to review what has been marked as exhibit number 2, correct?
Correct.
And Could you describe for us what was contained in exhibit number 2?
If it's the exhibit that I'm thinking about, it's a package that was produced by one of CNN's affiliate stations, and it's a story about the prosecutor being treated like a celebrity.
Okay. And just so we're clear, because you kind of qualified it a bit, I can show you what's been marked, if I may approach, Your Honor.
Okay.
Exhibit number 2. You reviewed that recently with your attorney, did you not?
Yes, I did.
Okay. And this is the disc that contains the video that, the story you were speaking of, correct?
Correct.
And you were seen in this video, were you not?
Yes.
Okay. And in terms of your observations that day, did you observe this behavior on part of Mr. Martinez?
Yes.
Okay. Did you see him taking photographs with members of the public?
Yes.
And did you see him signing autographs?
Yes.
Okay. The video that we see here, I believe, only demonstrates him signing one autograph. Were there other autographs that he signed to your, what you were able to see?
Yes.
Okay. And we saw a couple photographs being taken of him in this story. Did he take photographs of more people that were not contained in this video?
Yes.
Did you, having walked by this and being a reporter, I take it this would be something of interest to you, would it not?
Yes.
Okay. And in that regard, did you, I noticed when in the video you were walking by, but did you stand and take a few minutes to observe these festivities?
Yes.
Okay. Do you have any knowledge of how long this show went on?
A few minutes.
Okay. And going back to the other question, it's about the jurors and the ones you recognized, did you recognize any jurors being in the area to have witnessed any of this?
No.
Okay. Thank you, Ms. Wong. Judge, I would move to have exhibit number 2 admitted.
Any
For the
objection?
purposes of this hearing. No.
Exhibit 2 is admitted for purposes of this hearing only. Cross-examination.
I don't have any questions, thank you.
Thank you, Ms. Wong. You may step down. Court will hear argument on the motion after we have completed the Daubert hearing. Mr. Nermi, you may call your witness for that hearing.
Yes, Your Honor, and before we do so, we ask that Ms. Arias be able to take a seat in the, probably in the jury box would be best, so she can view what is happening on the screen.
Yes, you may walk up and take a seat in the jury box.
And as it relates to the witness, we would call Brian Neumeister.
Judge, if you could also have these two the next of kin who can sit in the jury box so they can also sit.
Yes. Mr. Neumeister, you were previously sworn in this case. You are still under oath. You may take a seat in the witness stand. Oh, well, is there any objection to him testifying standing at the box?
I'm not sure why you would want to stand at which box.
He wants to stand right there so that he can operate the machinery.
Oh, sure.
All right, you may stand to
And Judge,
testify.
my understanding is that we will need to alter the lighting, is that correct? Because it's barely visible at this point.
Okay.
And actually, Judge, if we could have this as well. Are you ready, Brian? Are you ready? Okay. Could you state your name for the record, please?
Norbert Ryan, Neumeister.
Okay.
Judge, I don't know if he's been sworn yet, or if he's going to electrocute.
I just told him that he's still under oath. We are, it's not,
Oh, but that's not hooked up to this.
right, but I need to make sure that this is working properly. Are you going to be using the,
I am, because we
Elmo
have
also?
we have the marked exhibit version of this that,
okay, then I need to make sure. There it goes. Okay. You may proceed.
thank you. And Mr. Neumeister, before we proceed into the work you did relating this to this photograph we see here as Exhibit 159, if you could take a look at the exhibit on the screen.
I'm seeing it on this screen here.
Okay. And you're familiar with Exhibit 159?
Yes, sir.
Okay.
Counsel, he has to speak up. Yes, sir.
And before we, like I said, before we go into the work you did on Exhibit 159, I want to go back into your background well, let me ask you this. Is there a simple explanation that you can provide to this that would describe the work you did on Exhibit 159?
To stick within downward standards, I did very simple, like enlargement. I didn't do a lot of fancy tricks, basically. I multiplied.
Excuse me, Mr. Neumeister, the court reporter is having difficulty hearing you. I'm not sure this is going to work.
Maybe if he could testify and then come down when he needs to? or-
Okay, perfect. We're going to give you a handheld
Oh,
microphone.
actually, Brian.
This may assist you. Let's try this.
Check.
This video and enhancement, enlargement, let's talk about your background in the video enhancement enlargement. How long have you been working in that field?
I've been working professionally with cameras since the 1980s.
Okay.
I'm sorry, we're going to need to try a different microphone. Try that one.
1, 2, 1, 2.
It's
No,
not
that
on
one's-
yet. You
that
need to
one's-
flip the switch.
1, 1, 2.
Okay, let's try it again.
Okay. I'm gonna ask the same question again. As to your experience in video enhancement and enlargement, how long have you been working in this field?
I've been working professionally since 1980.
And in terms of your background or training in doing video enhancement and enlargements, could you describe that for us?
Well, my dad was a executive at the National Broadcasting Company for 33 years, so I sort of grew up in the engineering department at NBC Television in Burbank. I began using still cameras.
Can we?
Yeah, it's very difficult.
You want to just come up there?
I think we're going to need to have you sit in the witness stand. So, Mr. Martinez, I guess you can stand on this side of the courtroom. All right, sir, have a seat.
Mike, did you get that? Sorry, Mr. Neumeister, I'm going to have you begin anew, at least with your education and training as it relates to video enhancement or enlargement.
I'm not sure if you got this earlier, so I'll just reiterate. I grew up with my dad being an executive at the National Broadcasting Company in Burbank, California for the network. So I had access to, it's kind of my second home away from home, working in the studios and hanging out with the engineers and working with the high-end camera, just kind of as a trainee, and they kind of took me under their wing. After that, as far as starting to work with cameras, the cameras that I started out with in the 70s were high-end cameras like Hasselblad and Leica. They're very high-end cameras.
Okay.
Throughout the 80s, I worked with really excellent photographers like Niall Latham, Tom Brzezinski, Bill Wallner, mostly all in Hasselblad and Mamiya format. At the same time, I was working a lot with professional video cameras for KPNX television here in Phoenix.
And as it relates to enhancing or enlarging an image, when did you begin working on that aspect forensically?
For magazines like Arizona Highways, for different things, they wanted images cropped. And originally, it wasn't done with Photoshop. It was done with enlargers. But again, these are the film days. We're talking about digital cameras right now. So we began cropping probably in the early 80s, cropping negatives or actually prints.
Okay. And when you mentioned the difference between digital and film, when did digital really come into prominence?
Well, it's kind of still, working its way in. There are those who feel that shooting, for example, on film, shooting Panavision has its proponents. Shooting on what's called a red or a Cine Alta has its proponents. So it's still coming in. It's probably 5 years ago, you could say that it started actually making a dent, where it started really cutting into the film market.
Okay. And in terms of enhancing digital photography, and what we're looking at here in 159 is a digital photograph, is that correct?
That's correct.
Okay. In terms of enhancing digital photographs, what training and experience do you have in that regard?
I've worked as a beta tester for a number of software companies that develop stuff beyond Photoshop. In other words, Clear ID, forensic, basically components that are made for forensic purposes. As far as working with Photoshop, I've worked with it since it first came out to the latest edition. It's fairly straightforward. It's good for doing portraits, family work, but it's not.
Please approach. Take about a 2-minute recess while we make some adjustments. Mind coming back up to the witness stand? We're going to try the equipment with you on the stand, see if we can make some adjustments.
Check, 1, 2, 3, 1, 2, 3, checking. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10.
Mr. Nermy,
Yeah, I mean, I can hear pretty clear if the court.
that was better. I did adjust it a little bit myself.
Yeah, when you get feedback, I don't think it's just turning down.
That's what I did. All right, thank you. If you wouldn't mind staying for just a few minutes while we start the hearing, and if we have any other issues, you can assist us. Thank you. All right, we're back on the record. Mr. Nermy, you may continue.
Mr. Neumeister, if memory serves, we were in the middle of discussing your background and education experience as it relates to enhancing digital photography. And I'm not sure that it came across very clear. You talked about using a Photoshop program. Is that correct?
Actually, the program we mostly use for forensic analysis is called Clear ID. It uses Photoshop as a basic starting off, jumping off point.
Okay.
But it takes it a lot farther. It uses a lot more CPU and a lot more GPU. And it does a lot of things that you really can't do with Photoshop. We do use Photoshop for general applications. We do have lots of plugins, which are ancillary programs that work with Photoshop. But when you're doing an enhancement for court, especially with a face, you have to be very careful about what you use. For example, if we were doing a license plate, I could do what's called pushing it a lot farther. We use what's called pixel stacking or frame averaging. When you're using a human face, you want to keep it as simple as possible as not to introduce artifacts into your work. In other words, basically, this is a straightforward enlargement without a lot of bells and whistles.
Okay. In that regard, you mentioned using this enhanced software. And you said CPU and GPU, if I heard you correctly, is
Yes.
that right?
Correct.
What are those acronyms for?
The CPU is, in our case, it's a water-cooled 12-core processor for processing the data. It's basically the heart of your computer. The GPU is the graphics card, and we use what's called a twice HD resolution graphics card. So the reason a lot of homicide detectives and whatnot come up to our lab is they can see stuff a lot clearer than with their systems due to the nature of our equipment.
Okay. Well, let's before we go into that aspect of it, have you testified in Maricopa County Superior Court regarding video enhancement enlargements prior to today?
Not specifically enlargements, but I have worked on photos where they were enlarged, but they didn't ask me specifically how did I enlarge them.
Okay. But you've testified in Maricopa County about enlargements you've done, correct?
Oh, yes.
Okay. And would you say, how many times would you say? Do you have any idea?
I actually don't testify that much most of the time because it doesn't matter if the defense or the prosecution gives me the evidence. About right now, I've got about a dozen cases that are with homicide or with the DA's office, prosecutor's office, and about the same amount with public defender's office, OPDS, here in Arizona. Most of the time, I am just asked to provide the evidence and I don't try to garner anything from the evidence. I present it to the attorneys for them to work with. In other words, I enhance it, clean it up, and present it. And I don't try to stipulate what's in the photos or make any interpretations of them. I just present them.
And in terms of these presentations, have you also worked in federal court cases as well or testified in those cases?
Yes.
Okay. Do you have any idea how many times you've done that?
The longest federal court case I had was, I think, the Charles Keating cases, which were, I think, they were 80 days. I've
And
also,
did you do video enhancement in that case or audio enhancement?
I did video and stills.
Okay. And was there a certification as an expert that you went through in those federal cases?
No,
Okay.
it's just experience of doing it every day for 30 years. The problem is, with a lot of so-called experts, they give them a machine, something that we may have worked as a beta tester on. which is a very simple machine, and they'll take a law enforcement officer, send them through a 30-day course, and call him an expert. When you've been working with high-end equipment for 30 years, you learn a lot by trial and error what works and what doesn't work. You also learn to work with the software manufacturers to create evidence or to create equipment or software that can better enhance evidence. We're on the phone quite often with manufacturers about glitches in software or whatnot.
Now, you mentioned you work for both the prosecution and the defense in Maricopa County. Do you also work for the prosecution and defense outside of Maricopa County? We've talked about federal cases.
Yes, I'm working for the U.S. Army this week for the CID prosecution.
Okay. And do you currently have any cases pending with the Mesa Police Department?
Yes, I'm representing the Mesa Police Department in a case.
Okay. All right. Now, what I want to talk to you about specifically, you started mentioning a few moments ago about the uniqueness, I guess, it will be my word, of the work you do when you're enlarging a picture of a human face, as we see here in Exhibit 159. Could you describe that for the court?
I'll just step back a bit. We have a federal case last week we were working on, and when working with the faces, I had to make sure that we had 4 different technicians working on this. We even had one of the gentlemen from the Saddam Hussein trial, a very high-end group of people working on that case. We have to make sure that we don't push a human face too far, because when you start increasing contrast, resolution, and again, by increasing resolution, that's a whole different ball of wax I can get into if you want to, but basically, you can cause artifacts or shadows that aren't there. Now again, if a typical situation I would get is a homicide detective would bring up a license plate or something off of a surveillance video, we would use different techniques where we can push the envelope a little farther, but on faces, to stay within Daubert, we don't modify them very much.
Okay. And how about when you're looking at, in general, before we go into Exhibit 159, the lens that's taking the photograph, does that affect your ability to enhance or enlarge a photograph?
There's a number of things. First of all, you're looking at the pixel size. This particular camera was an 8.1 megapixel camera. It's a consumer camera. It's got a consumer lens on it. It's a Zeiss lens. That particular camera uses what's called a Bions processor, one of the earlier ones that Sony was using. It's not a bad home camera. It shoots low-end video. It shoots a decent snapshot. That particular picture, and I don't know the reference number to it.
Well, again, what I want to do is before we get into this particular, and I have an exhibit to show you,
Okay.
but how when you're looking at the lens and the camera, is that something you account for when you look at the enlargements that you do on somebody's face?
Sure. There's things called bokeh. There's lens barreling, which is basically for example, on a wide-angle lens, you'll notice it's not what's called rectilinear. If you shoot something with a wide-angle lens, instead of straight lines on the edge, you'll notice they're curved.
Okay.
So you start looking for that, as it may affect the actual picture that you're working with.
Could you define for us rectilinear?
If you were to shoot a chip chart, which is a bunch of squares basically, which is used for registering cameras, mostly video cameras, but you also use them, we use Pantone charts.
Okay.
You shoot it and there's square lines on it. Now with what we call a rectilinear 50, which means that the lines on a 50 millimeter lens, a prime lens, all the lines would be horizontal and vertical when it's printed. If you start using something like a 16 to, well, I would say it depends on the camera, but let's say you used a 10 millimeter lens, which is basically a semi-fisheye, you would begin to see almost the effect that when you look through your peephole in your doorway, you see the bowing effect.
Okay.
It gives you a wider picture, but it distorts the edges. And when the lines aren't straight, it's not rectilinear. In other words, if any point, and it usually happens towards the horizontal edges of the picture, you'll notice that on a wide-angle lens, the trees or the houses or whatever may be warped a little bit in.
Okay. As it relates to, without going specifically into the work you did on 159 again, in terms of reflections that we see in photographs, Is it common for a photograph to have some sort of reflection?
It would depend on what you're shooting against.
Okay. Well, let's talk specifically about the cornea as we have here, and we won't go into the specifics of it, but also when you're assessing the photograph or reflection in a cornea, how do you account for the curvature of the eye, if at all?
Okay, there's two things you need to take into account there, and I will have to refer to this specific picture if you don't mind.
Sure, we're referring to, and for the record, Judge, on his screen also is 159. I see the screen is not, oh, there we go. Go ahead.
When you're shooting into, I've shot an awful lot of product shots, especially with sunglasses, and they're very tough because they reflect everything that they see. And if it's a curved sunglass, you notice if you've taken pictures of sunglasses very often, you have a picture photographer in there, or people standing on the outside, or the lighting crew, or whatnot for product shots. When you're shooting something, for example, off of the eye, you would have to take into effect the shape of the cornea and the bow of the lens. So was the lens rectilinear? What is the exact shape of the cornea?
Okay. And going specifically into your work here, having the experience and knowledge and training with this, you did all that in this case. Is that correct?
No, it was impossible to do actually. What you would do with Mr. Alexander is you would actually have to map the eye to get an exact curvature, because what you've got is basal tears which cover the cornea, causing the reflection. The reason this photograph, that we were able to blow it up, is because it was taken with the lens set at 16 millimeters, which is wide,
Okay.
on what's called a 1.025 chip, which is, I hope we don't have to get into the sizes of chips, but on the, it's a 1.25 format chip, which is 8 megabytes. I had enough pixel data to be able to zoom in and get what is reflected in the eye. Okay. And all I did was basically use a bicubic smoothing algorithm, which would not cause stair stepping. The other thing I did was I upgraded I went from an 8-bit format, which is native of that camera, to a 16-bit format to blow it up. And the reason you do that is it prevents what's called color stair stepping. It makes the colors smoother without augmenting the image at all.
Okay. Your Honor, if I may approach? Mr. Neumeister, I'm going to show you what's been marked Exhibit 1 for the purposes of this hearing. Do you recognize that document?
Yes.
And what is that?
That's the metadata that came from the exemplar that's on the screen.
Okay. And is that what you created, or what was?
It actually is on every photo that comes out of a camera. You'll have the metadata on it. So what I did is I just took it and copied it and put it down for reference so that the court would have a record of basically the shutter speed, the date, the ISO. The ISO is the light, in other words, the light speed, the maximum aperture, the pixel size, and if there was a flash that fired, and the DPI level. And it also has the date of the photograph on there, if the camera was set correctly, the clock on the camera. And I did not inspect the camera, so I wouldn't know.
I would move to admit Exhibit 1.
No objection.
Exhibit 1 is admitted for purposes of this hearing only.
Now, sir, drawing your attention to the work you did in this case, we talked about a reflection you were able to obtain from Mr. Alexander's cornea, correct?
Correct.
Okay. And why were you, this might be too big a broad a question, but basically, can you tell us why you were able to obtain a reflection out of his eyeball?
It's actually a very good question. There's a number of things in photography that are critical. One is how many PPI, which is pixels per inch, is available. And then also, because the person holding the camera shot with the camera low with the flash on, the white shower background acted as what we call a bounce. In the industry, we call it a foam core. But it acted as a bounce, so given the speed of light and the 1/50th shutter speed, what happened basically is the light left the flash, bounced off the shower enclosure, and lit the subject taking the picture.
So, based on everything you've told us, is there a way for you to estimate how far the photographer was from the subject of the photograph?
To do it accurately, you'd have to have a mapping of his eye, and then I would have to take the axial camera and map the camera lens, because many of these cameras have numerous different optics inside or different lenses inside, and very often there can be optical error, there can be misalignment. So without analyzing the camera and looking at the exact shape of the cornea, I could say within a few feet, but I couldn't say within how many inches.
Okay. And that, the few feet, not getting to an exact inch, that few feet would be determined how?
Well, again, there's a couple of ways. One of the things you're looking at is bokeh, which is the distortion of the background.
Okay.
There's not a lot of bokeh in here. In other words, there's not a lot of depth of field. Normally, when you shoot portraits, you use a fairly long prime lens, maybe an 80 or a 105, something like that, so that the picture of the person is in focus, but the background it looks blurry and soft and, more palatable. This was shot 16 millimeters, basically, because it says on the actual metadata that to shoot with 16 millimeter and get a full face like that, you'd have to be fairly close.
I want to, if I may approach again, Your Honor.
You may.
I want to show you what's been marked as Exhibit 2 for purposes of this hearing. Could you take a look at that, sir?
Yes.
And could you tell us what that photograph represents?
That is an enlargement at the stock 72 DPI, or PPI, basically, or DPI rather, of the eye. And what I did is I left it at 72 DPI the first time around. The only thing I changed was I increased the bit depth to 16 bit. And briefly to explain, an 8-bit picture has the availability to produce about 16.8 million colors. 16-bit, you're into the trillions of colors as to how many colors you can get. What that prevents is when you're going from red to pink to different colors, it prevents when you blow it up from the colors from being choppy. It smooths it out. So anytime you're dealing with a forensic photo, you'd want to go up to a 16 bit. So basically, it's at the stock DPI at 16 bit.
All right. And this is the eye we see as reflected in Exhibit 159. This is a focus on that.
On Mr.
left eye?
Alexander's left eye.
Okay. I would move to admit Exhibit number 2 for purposes of this hearing.
No objection.
Exhibit 2 is admitted for purposes of this hearing only.
And Mr. Neumeister, perhaps if you could be so kind as to, you have Exhibit number 2 on your slides.
I step down.
Focusing in on, this is a reflection of the left eye as depicted in Exhibit 159, correct?
Mr. Alexander's left eye, correct.
Okay. And could you tell us what we see? You said you enhanced it to 720?
No,
72
on that
dpi.
particular, it's what's called 72 DPI, which was the stock DPI that came from the camera. That's dots per inch, and it has to do with printer, not the camera.
Okay.
It's an output format.
All right. And based on, from this point in time, we can see, what can we see? I mean, can you make any conclusions from just this?
Well, first of all, the camera or the projector that's putting out the HDMI or the HD
Okay,
output
well,
on,
this one.
that's twice the resolution just about as the RGB monitor that's coming out, because that's an NTSC 720/46. That's a 1080i.
Okay.
What that means
Let's
is,
focus our attention on this one, then. What can we see here?
basically what it is a reflection from the cornea, and it's interesting because if it was not in the middle of the pupil, we would not have got that kind of photo. What it is, if I may stand,
You may stand.
it's basically a camera being fired from this position, or maybe like looking at the viewfinder from this position. And the reason you can tell that is because of the center of the flash, and you can see,
The center of the flash, is that what we see here?
right, and you can see the chromatic aberrations around that, which are the colors. And that's basically what you can see. I can see a little bit more of it on, that's a fairly low, the next slide's a little more higher, it's a little higher resolution.
Okay.
But can you recognize who the person is taking the photo? No, there's not enough a PPI, which is pixels per inch. All it is representing that somebody is taking a photo of Mr. Alexander with the camera held about chest height.
And we can tell the height relative to the cornea, correct? The height, the level of the camera relative to the cornea, to some degree?
I'm not sure what you mean.
Well, you mentioned you stood up and you demonstrated to us how you could see that the photograph was being taken.
It would actually be more like this.
Okay.
Okay. So I don't know the height of Mr. Alexander, and I don't know the height of Miss Arias, so it'd be purely speculative.
Let me show you what's been marked as Exhibit 3, if I may approach.
You may.
Could you describe for us what we see in the exhibit I've just shown you?
It's the same image, only instead of 72 dpi, it's been taken up to 2,880 dpi, it's actually to make it easier to work with. And let me backtrack one of the reasons we do that. In Clear ID, on a digital camera, I don't know if any of you had a computer screen or a digital camera where you notice there's maybe one white dot or something on your computer screen that's always there.
Okay.
It's called a dead pixel. First thing I have to do is go through the luminance tracks and the RGB channels of the CCD chip to see if there's any bad pixels before I blow it up. And it's a lot easier to do that at this magnification.
Okay.
So I went through each color channel and be able to look for dead pixels, because if there were some, I'd have to blow it out. And I was able to do that, and again, in Clear ID, going through each individual channel, and didn't find any what we call dead pixels.
Be moving to admit exhibit number 3.
No objection.
Exhibit 3 is admitted for purposes of this hearing only.
And Your Honor, if Mr. Neumeister could.
Yes, you may
Stand.
step down.
Doesn't look like it comes up very well at all on the big screen, so let me go over here.
Yes, it's because of the resolution of the monitor. We definitely need to play it back on the 1080.
Okay.
And actually, in my lab, it's twice the resolution of that.
Okay, so what we're seeing here is half, if you will, as good as what we could see, or what the jury could see if they were in your lab. Is that correct?
That's correct.
Okay. And now what we see here is the same flash area, correct?
It's the same picture. The only difference is it was upper res to 2880 DPI, and that was for me to do a little bit of just testing to make sure there weren't bad pixels and whatnot. It does give me a little more latitude as far as working pixel by pixel, looking at it to make sure there's, like I say, what becomes critical. Let's say, for example, somebody has a mole on their face, but there's a dead pixel in a camera, and it looks like there's a dot on a person's face. It could be caused by the camera rather than actually being on a person's face. And I've had that in cases, actually, where there was a bad pixel. Okay. So I wanted to make sure that all the pixels were good, so I worked at 2880, which is not unusual in these cases.
Okay. And what you were able to discern, I believe, from what you told us before from looking at this, is that there were no dead pixels.
I only looked at that. I did not look at the entire picture. I just looked at the part that was asked to enlarge.
Okay. And so your focus here is in this area of the cornea, correct?
Actually, in the pupil area.
Pupil area, I'm sorry. And based on this, do you begin to see more in this picture than merely the flash?
Yes, but again, I was able to actually trace what I was able to see in the studio to make it. I knew we'd run into the situation in court where we don't have the equipment to really show everything there is to show. Again, that's why homicide comes out a lot to our lab, to look and see what's really there. So I did an outline, a rough outline of what I can see in the lab.
Okay, let me show you then, regarding that outline, if I may approach, Your Honor, what has been marked as Exhibit 4 for purposes of this hearing. You could take a look at that. Is that the same photograph, but instead with the outlines of what you referred to?
Yes.
And I would move to admit Exhibit 4 for purposes of this hearing.
No objection.
4 is admitted for purposes of this hearing.
And Mr. Neumeister, if you would.
You're on.
Yes, sir. Can you step down?
What you've done for purposes of demonstration here is that you've shown us a figure that is visible on your equipment but not visible, completely as visible here, of a person holding a camera, correct?
I think the difference would be equated to the difference of what's being up on the overhead as opposed to what's on the HD screen. It's quite a bit of difference, so double that, and yes.
Okay. And this outlining you've done, that's not an alteration to the photograph, is that correct?
No, the only thing that was changed on it, the light level, the overall, what you call brightness, was cranked up by about 19%. In other words, it made it easier for me to see. When you get into low pixel resolution or low PPI, the first thing that begins to drop out are what are called the black values, the darker values on, if you put it on a vector scope or on a waveform scope, the lower values drop out first. So in order to be able to actually trace it more clearly, I enhanced the brightness, which again is nothing fancy, just so I could trace it more easily.
As it relates to what we see here, we see the figure with the arm up. We see an area up here with light. Can we speculate as to what that is?
Can you point that out?
The area above here where it looks like the head or shoulder?
Oh, it looks like, if I'm seeing what you're pointing at, it looks like, again, there's a thing called blown out, which means when there's too much light on the subject, the white values tend to bloom.
Okay.
So it looks like a blown out, it looks like the face, blown out face, and to screen right of that would be the hair.
Now, as it relates to this enhancement or enlargement, this exhibit dictates that it is at 2880 DPI. Is there further enhancements you could make to the photograph without altering it?
Could I make it cleaner? Yes, but it wouldn't be Daubert standards because there's a very good chance that I'd be creating an image rather than enhancing. And with license plates or very often, again, with homicide, they'll want to see everything they can, and I'll show everything I can. But as far as what I can present in court, I can only take it so far and stay within not creating an image.
And this is as far as you felt like you could take it without making any alterations and or creating an image, is that correct?
I stayed on the conservative side. I actually did a few others. I went up to 7,500 DPI, and I didn't really see any benefits for it. I did HDR, which is high dynamic contrast pixel stacking, just for my own edification. I knew that it wouldn't be admissible, but I just wanted to see what I could see. And yes, I could see a little more, but I don't think it would be good evidence.
Okay. Thank you, sir.
Cross-examination.
Sir, you indicated that you testified before. How many other times have you testified? Let's start with Maricopa County Superior Court.
I would say about a dozen or so.
And what areas have you addressed in your testimony in those dozen or so times that you testified here in Maricopa County Superior Court?
Mostly video and
Well, no, let's be specific. The last time that you testified here actually wasn't video, was it?
you're talking about in this court.
I'm talking
Yeah, it was
about,
audio.
let's do it this way. I'll ask the questions and you can give me the answers. In terms of testifying in court, when was the last time that you believe you testified in court?
It would be on this case.
Did that have anything to do with video that you testified to?
Objection is to vagueness. Are you talking about this case or another trial?
Sustained.
Well, sir, what are you talking about?
Can you re-ask the question?
No. I'm asking the question is, when was the last time that you testified in Maricopa County Superior Court?
In this case earlier on.
And what did you testify to in this case in Maricopa County Superior Court? What did you testify about?
I enhanced the audio for this particular case.
That has nothing to do with video, correct?
That's correct.
And in fact, part of the reason that you testified in enhancing the audio, what the motivation for you was that so you could become qualified as an expert to testify with regard to video, to audio, correct?
Objection is to relevance.
I have testified an awful lot to audio.
I'm not asking that. I'm asking whether or not you had ever testified previously in any court as to the work that you did in this case previously.
Objection is to relevance, the apples and oranges. If he wanted to challenge his audio qualifications, he could have done so at the time.
Overruled. You may answer.
One more time, Juan.
Sir, with regard to what you testified previously, isn't it true that the motivation for you testifying involving the audio was so that you could be qualified as an expert in that area?
I've testified numerous times.
So the answer is no?
The answer is no.
So what other case have you ever testified to audio enhancement such as the one that you attempted to testify about in this case?
Again, objection, if the court recalls, Mr. Martinez stipulated to the fact that that was Mr. Alexander and Ms. Arias' voice on the recording. Now he seems to be attempting to relitigate it in a separate proceeding.
Counsel approach, please. Overruled. You may proceed.
So, sir, with regard to this audio enhancing, what other cases have you testified to?
I've worked on many, many audio cases. The last case I would testify for was for your office with Eric on a shooting as to the decibel pressure of a gun.
I'm not asking about the decimal pressure of gun. I'm asking about the audio recording. You indicated that previously that you've testified in other cases involving audio recordings. What case was that? Just tell me the name of that case.
The name of the case, again, I've got 29 homicides right now. I work 7 days a week. The name of that case, I could look it up, but I could tell you it was an audio case because they wanted to hear what was going on in the background in the conversations before the shooting occurred. In fact, I've just been retained by your office again on another case.
I understand you want to tell us that you were retained by our office. What I hear you telling me is that you can't tell us the name of the case, right?
Not offhand, no. Again, I don't get very involved.
How long ago was it, sir, that you testified in that case, supposedly?
Well, it wasn't supposedly, I did. It was a few months ago,
Okay.
and I don't know the date.
What was the name of the judge?
Objection, is there any relevance to this, Judge?
I'd have to look at my notes again.
And did you testify for the prosecution or for the defense?
Prosecution.
And what was the name of the prosecutor?
Eric.
Well, I thought you just told us that with regard to Mr. Bostad, you testified about something different. What was it that you testified to in the case involving Mr. Bostad?
There was a gunshot, and they wanted to hear what the audio was between the conversation of the people before the gunshot.
And that was the time that you testified previous to this, correct?
Yes, again, most of my
So
work
that's
is
yes.
lab work.
So that's yes, correct? That is the previous time that you testified, correct?
I've been at quite a few, I've done quite a few of the evidentiary hearings. I don't know if you'd call that testifying.
However you want to, before a jury, let's define it that way, okay?
Okay.
Have you testified in any other area? We know you're testifying about enhancement here, and then we also know you testified about some audio issues previously. What other areas have you testified to in the past?
Video.
And by video, what are you talking about?
Usually we do a lot of enhancement of, for example, surveillance videos. We get a lot of calls for that. For example, the Phoenix Homicide just called me a while, well, I get quite a few for Phoenix Homicide, where they need a small piece of video blown up into something they can use. Most of the time what we do is called frame averaging, where we compile video and make
I'm
good
asking
stills
what
out
you
of it.
do, not what we do, if you don't mind. What it is that you do.
I have equipment that the police department doesn't have, and it further enables them to use, for example, photos or pieces of video that are cleaner than they can come up with.
So there's only two areas in which you've been qualified as an expert, sound and then audio, correct?
No, I've testified on pictures because a lot of times the pictures I've lifted have been lifted from video. And what they've done is I've frame averaged the video to create still pictures.
So that involves pictures, which is
Correct.
what this case is about, and then also audio. So are those the only two areas in which you've testified?
Audio, video, and pictures.
And that's it?
That's correct.
Sir, you also indicated that you are working for the city of Mesa. What are you doing for the city of Mesa?
I'm representing the Mesa Police Department in a shooting in a civil case. It's two officers involved in a shooting against a civilian. It was a fatal.
I understand that, but what are you doing in that case? What is it what kind of expertise are you lending to that case? What are you doing?
I enhanced the audio from the officers' mics, so they wanted to hear what the gentleman in the background, the person who was shot, was saying, and they wanted that enhanced, so I did that.
And in this case, what you did is you enhanced what is the left eye of Mr. Alexander, correct?
I didn't enhance it, I enlarged it.
You enlarged the eye of Mr. Alexander, correct?
Correct.
And one of the things that you did with regard to that is that you then drew some lines, and we're looking at exhibit number 4, correct? Is that yes?
I don't know if it's number 4, but that's what we're looking at.
Well, then this is the one I'm holding. You see that? This is number 4.
Okay.
And These are the lines that you drew, correct?
Correct.
Your eyes with corrective lenses are what?
20/20.
And do you see better than anybody else who has 20/20 vision?
We have better equipment, almost
I'm not
double.
asking about the equipment. I'm asking about what you see with your eyes.
No?
And if you were to present this evidence to the jury, you would, of course, for example, have exhibit number 3 available, wouldn't you? Correct?
Yes.
And if we take a look at exhibit number 3, that's the one that doesn't include your lines on it, right?
Correct, but it'd be better to be looking at it on HD than on the RGB.
I understand that, but exhibit number 3 just shows us the same photograph without the lines on it, right?
Actually, what's the marking on exhibit number 3? What's the DPI marking?
It just says exhibit number 3 on it.
It should say on the front how many DPIs. On the actual photo, there should be a marking. Yes, correct.
Okay, now you've looked at it,
Yeah,
it doesn't have any markings on it.
yes.
Isn't it true, sir, that if we were to show that to other people, they could disagree with you about these markings that are here, couldn't they?
Sure.
So that, and there's no scientific test, for example, that we could apply so that we could take a look at exhibit number 4, for example, and verify that your lines are accurately drawn as to what may or may not be in the background, right?
Well, what we could do is I could actually
No,
put
sir.
up,
No, sir, I'm asking, is there a test that we could administer, like a cancer test, that we could administer so that we could determine whether or not your lines are drawn correctly?
there are procedures where we could use magnetic lasso attached to luminance and chromatic values.
So you're saying that everybody who looks at this photograph would draw the exact same lines. Is that what you're saying?
I would say if they had the equipment I had and they were asked to trace what I had, yes.
So for example, assuming that my eyes were 20/20, and I said to you, and I'm looking at exhibit number 3, I don't see anything that you have here. Would you have any reason to dispute what my eyes were seeing?
Objection calls for speculation.
Overruled.
I would say you're not looking at it through the equipment I have been able to look at it for.
Well, but the equipment isn't here for the jury to see, is it?
Right,
Yes or no?
but if you're looking at it on that monitor, it's much better than on the RGB monitor.
And these are your lines, again, if
Yes.
I were to say to you, I'm looking at that, with all the enhancements in the world, I can't see it. You wouldn't be able to dispute that, would you?
And that would be up to the jury.
That's right, it would be up to the jury to decide what they see, not you, right?
That's correct.
I don't have anything else, thank you.
Redirect.
Mr. Neumeister, let's talk a little bit about the capabilities and what we have up on your on the screen from your projector is what's been marked as Exhibit 4 for purposes of this hearing. Sir, it seems that there are limitations, if you will, as to what we can see here versus what we would see in your lab, correct?
Yes, we have about twice the resolution.
Okay. And earlier when we were speaking, you discussed how using what we see up on the screen here, this standard definition type display, what we see on the wall screen and the court equipment, what you would see in your lab is this, what we see on your screen is twice as good as this, and what we would see in your lab would be twice as good as what we see from your projector, right?
That's correct.
Okay. And when we say twice as good, of course, are you talking about estimating pixels, or how do you come to that determination, twice as good?
It's twice 1080. 1080 would be HD. It's twice 1080 resolution.
Okay, well, I see 2880 DPI on this.
That's just the printing resolution. That has nothing to do with the actual viewing of the equipment.
Okay. And so even though we have this picture that shows this DPI dust per inch, correct?
Correct.
Okay. Even though we have this photograph showing the DPI, what we see here projected is certainly not as good because we don't have the equipment to view it in that way, correct?
Correct.
Okay. The best evidence then, if we were to, you were asked about what people might see, what Mr. Martinez might see, et cetera, with their vision. The best evidence of what anybody would see on their own would come from viewing it at your lab in front of your equipment, correct?
As an example, Detective Butcher has a triple homicide. There was a cold case, and they weren't able to make out what kind of vehicles were involved in the two suspect vehicles, and we were able to, she was able to bring up the evidence. We were able to bring in an expert and enhance it enough so they could tell exactly what make, model, and year the vehicles were, which was a good, and that was last week. Was a
And
good
that was
chunk of the
something
case.
visible in your lab that wasn't visible
They weren't
elsewhere?
able to see that, no.
Okay. And so what you've done here, realistically then, is a visualization or demonstration, if you will, of what a juror, and I know we can't, Mr. Martinez is talking to you about psychic, abilities, trying to discern what somebody would say, but reasonably speaking, what you have here in these lines is an alternative to somebody
Just need to hit the space bar. There you go. Thank you.
to somebody being in your laboratory, correct?
I would say that what I have done is actually, it helps the juror to see what I can see. Can you recognize, it's a fairly straightforward thing. What it is the reflection, it's light bouncing off the back of the shower wall, illuminating the person taking the picture. The only reason we're able to see the facial and hair is because the camera was held lower. Can you identify who's in the picture? No.
No. You could just identify that there's a person holding a camera like this about a few feet from Mr. Alexander, right?
That's correct, and that would be just a simple logical conclusion.
Okay. Thank you, Mr. Neumeister.
You may step down.
Thank you.
Anything else on this issue in terms of testimony?
Not in terms of testimony, Your Honor.
Mr. Martinez, do you have any witnesses in terms of testimony? Are you prepared to argue?
I am, Your Honor.
All right.
Your Honor, I guess the state should proceed. It's his oral motion to oppose admission, so unless you want me to proceed.
Mr. Martinez, sure, the state's position.
Basically, what the defendant is asking the court to do is to take a look at what is clearly a dog and say that it's a person standing there. That's what I saw when I was looking at the photographs. And if I can stand here and ethically say that, then really what we have here is a situation where we have another sort of fantastical kind of type of evidence that is being asked to be presented to the jury. One of the things that we need to ask, and as the court probably knows, is whether or not this expert's technique or theory can be or has been tested. There's no way that we can test what he sees because that comes straight from his eyes and then he draws some of the lines. I will avow to the court that what I saw was a dog. I saw some ears and then I saw a snout. So it cannot be tested. We cannot, for example, like a drug test or blood test, we can't submit it to somebody else for verification. That can't be done. The issue also is whether or not this technique has been subject to peer review or reliability. And the problem here is the reliability of what he is attempting to present to the jury. Again, it's the state's position that if we got 10 people to look at that without telling them what they thought it was, that 10 people would come up with something different. And so this proposed evidence is not reliable. In terms of this test again, and the reliability is what is the potential rate of error? In other words, if 10 people look at it, how many of those 10 people will think it's a dog? How many of those 10 people will think it's a gopher or any other sort of animal? We just don't know. There is nothing that has been presented by the defendant that indicates that there is any statistics with regard to the rate of error. And again, he talks about his lab and how he's looked at it, how the resolution's a little bit higher, but what are the standards or the controls that he uses such that we could take a look at those, we could apply those, and then say, this is exactly what everyone would look at. And I keep going back, for example, to maybe a blood test, maybe a test for cancer. Those are the ones that can objectively be verified. This is a subjective test, if you will. And if you have a subjective test, then you're going to get subjective answers. And there was no testimony that's been presented that this approach has been accepted in the scientific community. It is the state's position that this is really voodoo, and that, as I said, as soon as I saw that, and they put it up on the screen, and I thought, well, that's a dog. And I can tell the court, if we take a look at exhibit number 4, that what I saw, these right here were the 2 ears. If you take a look at it, here's the mouth, and here are the eyes. This looks like it may be a stick that the dog has in its mouth. So if I can make those avowals, and quite frankly, that's exactly what I thought as soon as I saw this, then there is nothing scientific about this. This is just an individual who wants to impose his views on the jury, and the jury can look at this. If they want to present the enhancement without his testimony about what he sees, or if they want to just present this enhancement and say, take a look at it, I can understand that they can do that. But in terms of his ultimate opinion, that there's a person standing there and that sort of thing, I don't think that they've carried the day. And I know that this individual has talked about Daubert at least on 2 occasions when he was testifying, but he's not a lawyer and he really doesn't know what he's talking about when he speaks about that. So I would ask that the court preclude this evidence. Thank you.
Mr. Noe.
Your Honor, throughout the course of this trial, we have seen numerous text messages and emails that counsel for the state at one time avowed didn't exist. We've seen hundreds of them. The same voice that tells you that these didn't exist actually stands before this court and claims he sees a dog. That's the standard. Mr. Martinez says, hey, I see a dog, so this isn't admissible. That's not the standard. What Mr. Martinez sees or what skewed view he wants to take of reality is not what's before this court. What's before this court is whether the work that Mr. Neumeister did was scientific, within the field, and in generally accepted terms. This is science. Mr. Martinez takes a limited view of science, saying, if it's not a blood test, if it's not a cancer test, if you can't do something definitive, it's not science. Well, that's just not true. But soon, Mr. Martinez will bring a psychologist up and talk about her work. Well, it's the same, right? It's not this definitive test. So this misguided and, shall we say, altered view of what now is science and what is not science that the state is taking is just that, misguided and based on a desired outcome. The fact that this evidence is adversely probative and damaging to Mr. Martinez's position and the state's position doesn't mean that it does not meet the Daubert standards. And that ultimately is what the argument Mr. Martinez made was. Mr. Neumeister testified that he used the computer software that is commonly used in his field to enlarge this photograph. He talked about working with the developers. He talked about working with other experts, and that they all use this Clear ID software. Mr. Martinez, in his argument, evaded that reality. There is no doubt about the fact that what and there has been no dispute, there was no questions of Mr. Neumeister regarding challenging what he did. There was personal character assassination, trying to claim his expertise was invalid, but there was not actual evidence disputing, and the state has not put on an expert disputing what Mr. Neumeister did. Now, to some degree, the state has said, well, they can show the first 3 pictures, but, Mr. Martinez is afraid of the bite in this dog, I guess. But what we have here ultimately, Your Honor, is 2 alternatives. Ms. Arias has a due process right to present the best evidence available to the jurors. I see 2 alternatives. The court can preclude this photograph with these marks on it, which are merely traces, not enhancements of the photograph, mind you. But if the court were to do that, then the alternative would be to bring the jury up to Mr. Neumeister's lab and have them look at the photographs without this trace. As a matter of fact, if the court was inclined to preclude this photograph, I would say the court should do the same in a Daubert hearing, because that is the only way it's going to be able to see the validity of this outline. I've seen it, I understand it, I've been to the lab, and this is merely a trace of what is visible when we have the proper equipment. So, Your Honor, what I would say for the ease and the logistics of this case, what we have here is a scientifically valid results from the the enlargement of the video. What is demonstrated to the jury with this outline is merely something that they could otherwise not see because of the equipment limitations of this courtroom. So again, under Trombetta, Ms. Arias has a right to present a full and complete defense. There has been no argument that this is scientifically invalid other than merely bluster. The reality before the court is the 2 alternatives are there. It's either this photograph or what we see in Exhibit 4, or it's bringing the jury up to Mr. Neumeister's lab. Based on the science of it, based on the logistics of it, we believe that all the photographs 1 through 4, should be admissible in front of this jury.
Mr. Nurmi, under Rule 702A, the court must find that the knowledge your expert intends to testify about will help the trier of fact to understand the evidence or to determine a fact at issue. What is your position with regard to Exhibit 4 and that requirement?
Well, to answer that question, I would go back to turning the court's attention back to 159. Because Exhibit 159 is a series of photographs that, whether seconds in time or minutes in time, depending on whose theory of the case one wants to accept, was a photograph taken. The testimony of Ms. Arias was that she was indeed taking a photograph of Mr. Alexander exactly in the way that this picture depicts. It shows the flash, obviously, in the middle. Mr. Neumeister testified to that, the flash near the middle of the body. And it demonstrates that she was, in fact, holding the camera in the way that she dictated. This photograph also shows, or Mr. Neumeister's work on this photograph, and the reflection also shows she's got both hands on the camera and she's a couple feet away. It completely supports her testimony as to what happened that day. That's how it would assist the trier in fact, because it relates to where her hands were. No knife in their hands, no, just a camera. And in fact, that she was a few feet away. So that's how it helps the jury understand the testimony and the evidence presented. And there have been many of attack on Ms. Arias' credibility, and this demonstrates exactly, it verifies that she was in fact telling the truth. That's how it assists the trier in fact.
All right, thank you. Mr. Martinez, anything else?
Just to note that I don't see a camera, I don't see a knife, I don't see anything other than a blotch and if he went to his place of business, I know that I said that I saw a dog, it looked like a German Shepherd, perhaps I would probably see a Mexican Chihuahua. That's the problem with this particular evidence. It doesn't show anything, and it's subject to interpretation.
All right, thank you. All right, I do not have the comments to Rule 702 as amended in January, and I want to review those comments before I rule. So at this time, I will hear argument on the other motion, if you're prepared.
Judge, I have one, the misconduct motion.
Yes.
I have one bit of evidence that I'd like to play for the court as it relates to. And for the record, I was just handed this morning, just before the proceedings began at 9 o'clock, the state's response to motion for mistrial. I have reviewed it. One of the claims made is that Mr. Martinez is claiming that he did not intimidate witnesses himself inside the courtroom or directly. I would like to play for the court an interview that Mr. Martinez conducted with Dr. Samuels prior to his testimony marked as Exhibit 3, if I may publish it for the court.
And Judge, I'll object on grounds of relevance. That has nothing to do with whether or not the jurors saw Mr. Martinez signing any autographs or whether or not the jurors saw the taking of the photographs. That's the purpose of the motion that we have here. If he wants to discuss the other motion, then we can discuss that too, but let's discuss one thing at a time so we can get a specific ruling as to the first motion. If he wants to talk as to the second one, we can do that.
Mr. Nurmi, the relevance of this particular piece of evidence.
Your Honor, it is all one in the same. We filed a motion for mistrial for prosecutorial misconduct, the inability to provide effective assistance of counsel because Mr. Martinez has engaged in behavior imitated by those, and some of it is in sealed proceedings, but imitated by those following the trial to harass and intimidate witnesses. And this interview that he did with Dr. Samuels is audio evidence of him intimidating, attempting to intimidate Dr. Samuels as he did Miss LaViolette in chambers. So that's how it's relevant. And I thought that's the evidence the court wanted to hear, or the motion that the court wanted to hear evidence on at this time.
Judge, I've asked for a ruling first on the one where Ms. Wong testified, so that we could at least, because I know later on there's going to be issues as to morphing or mixing these two. So we could address that one first, and then we can address the other one.
All right, I will hear argument on that motion for mistrial. Mr. Nurmi.
Well, Your Honor, and I will preface my comments in that regard by saying this. Obviously, we know that prosecutorial misconduct is a cumulative issue. So it talks about, it relates to the infesting of the proceedings with general unfairness. One of the things that I talked about, and one of the things as the state mentions in their motion, numerous motions for mistrial. The state has thrown evidence, he's thrown his pen, he's yelled at witnesses, and we won't go into the intimidation of witnesses, I guess, at this time, but this is certainly a precursor to that same motion. And as it relates to this motion, he chose to walk outside and sign autographs and pose for pictures. This conduct, fortunately, based on what we've learned, was not viewed by any of the jurors. But we know that the previous conduct was. And as the state even implies in citing Aguilar and Poole, improper purpose, indifference to a significant resulting danger of a mistrial. He's standing out there having a fan club meeting. You know, putting aside the unprofessionalism of that, this sort of behavior does in fact, and is in fact, igniting a mistrial in this case, is igniting the fact that this kind of behavior is exactly what has led to witnesses being intimidating, because he is, you know, the great one, and he's out there signing autographs. And this infuses the trial with unfairness, and it is grounds for a mistrial when we consider every other item, every other action that he has done that has preceded this, including avowals of seeing dogs and text messages didn't exist. It's all one and the same, Judge. It's hard to separate it out, as try as we must. It is one big continuum of misconduct that has began from before this trial. It has proceeded to date, and I'm sure it will continue onward.
Mr. Martinez.
We are talking about an isolated incident where the prosecutor walked outside and people came up to him and requested specifically to have a cane sign and requested that he pose for pictures. That's what we're talking about. Somehow the defendant wants to connect that with everything else that the social media does. What the social media does, what the media does, that's not something that can be visited upon the prosecutor. That is something that is not connected. They haven't shown a nexus, any connection between what the prosecutor did on one occasion, something that clearly was unscripted, clearly was unanticipated. And so they want to say, well, that's something that affected the jurors. And that's how this case actually, or this issue actually was raised, that it affected the jurors. When we discussed this with the jurors, of course, we know that they weren't. And so defense counsel still continues to grandstand about this particular issue and attempts to piggyback other things to it. We knew, even before Ms. Wong was called, that the jurors were not affected. We knew that going in. And so rather than take the avowal of counsel that she saw nothing, we then go, and even if she had seen something, the jurors had already indicated that they hadn't seen anything. So instead, what do? We waste the court's time, we waste the prosecutor's time. Basically, we just come in and waste time, and that is an ethical issue. If it's an ethical issue, it's an ethical issue for the defendant, because they know that the position they are taking is spurious. And if we remember how this started, they were indicating that jurors actually saw Mr. Martinez. That's how this started. So when we start talking about all these other issues, they cannot then be included here. And so noting that there's this, if you will, ethical, unprofessional type issue on that side, because basically what they're doing is wasting everybody's time, then that's problematic. I say it's a waste of everybody's time, except maybe for defense counsel. Perhaps they could add a couple more pennies to their kettle that they have.
Anything else, Mr. Nurmi? With
No, I'll
regard to
just note
this
the
motion.
improper argument as it relates to counsel. I'm sorry that our interest in fulfilling our duties as counsel and protecting Ms. Arias's rights interfere with his desire for stardom. But based on everything we've seen in the case law, and again, we will supplement later on, but I believe mistrial is the appropriate remedy at this time.
All right, the court has considered Exhibits 1 and 2. I've considered the testimony of Ms. Casares and Ms. Wong. I've considered the information provided in the sealed proceedings during which each of the jurors were questioned regarding whether they saw Mr. Martinez in front of the court building. And all the parties and defendant were present during that closed proceeding. The law provides that to prove prosecutorial misconduct, the defendant must show first that the state's actions were improper. Setting that aside, I'm going to go to the second showing that must be made, and that is that there is a reasonable likelihood that the misconduct could affect the jury's verdict, thereby denying the defendant a fair trial. In this case, there is no evidence that signing autographs and posing for photographs under these very limited circumstances, could affect the jury's verdict since there were no jurors present. Mistrial is the most dramatic remedy for trial error and should be granted only when it appears that justice will be thwarted unless the jury is discharged. The court cannot make that finding, so the motion for mistrial is denied. Now, with regard to the next issue, Mr. Nurmi.
Yes, Your Honor. I should probably have this remarked as Exhibit 1 of the next proceeding, next mistrial motion. Your Honor, it relates to the mistrial motion related to inability to provide effective assistance of counsel. I would refer the court back to, we had some sealed proceedings in which Mr. Martinez attacked Ms. Violet. During her testimony, these took place while she was still on the stand, attacked her for her response to someone who had threatened her. And I will not go into the specifics because they are sealed, but I will also refer the court, and I've published what has been marked as Exhibit 1, the copy of the interview the state conducted with Dr. Samuels. Before his testimony, this was provided to by the state, provided to the defense by the state. Your Honor, if we could, for some reason the audio file is coming up with JPEGs in the system. I was going to have Mr. Neumeister play it through his laptop.
Yes.
Today's date is March 14th, 2013. My name is Paul Martinez. We're going to do interviews. What is your name, sir?
Dr. Richard Samuels.
And sir, I noticed that you indicated that you finished your study on this case in June 21 of 2010. At least that's what your report says, right?
That was the time that I completed my report.
Right. Okay. Well, it says your study. Right. And I noticed that you went back in December of this previous year to speak with the defendant.
Yes.
If you had already finished the report and you were done, why were you visiting her as late as December of last year?
I seem to recall that she was feeling kind of depressed, and I think we had seen some additional. I don't have the dates in front of me, so you have to excuse me. I'm just trying to.
December around before Christmas.
This past Christmas.
Right.
I think that may have been related to that new material that came out of that drive. That I got a whole bunch of pictures, materials, pictures, photographs, I think some text messages or some such thing. That, given the fact that she was kind of feeling down, it was decided that I would go and spend some time talking to her.
You said that she was feeling down and you were
Depressed.
and you were there to talk to her about that, or?
Well, amongst other things, but my goal was to question her about some of the pictures that were...
Right, but you said she was depressed, and that's something that you also talked to her about.
I don't remember spending a lot of time with it, but because I didn't find her as depressed as I thought she might be.
Did that have anything to do with this presentation involving this instrumental versus expressive homicide?
No, not at all.
When did that come about?
Well, it comes about from the very beginning.
Do you remember when we had our interview?
I do.
You never used those two words, correct?
It was never asked.
I understand that it was never asked, or that you say it was never asked. You didn't use those two words, correct?
No.
And your report never used those two words, correct?
That's true.
So when did you begin using these new words?
When I started preparing to testify, and I hadn't
Okay, hold on, because I only have a short period of time.
Okay.
When did you begin to prepare to testify?
Several months ago.
And that's when these words popped up a couple of months ago.
Yes, well,
Okay, then thank you. Like I said, no, this is my interview. You can interview at your leisure.
I'll ask him questions at the end.
Okay, so this was a couple months ago that this came up.
Maybe it was like 4 or 5 months ago.
When was it? I'll let you tell.
I don't remember exactly. I have to look at my appointment calendar. I don't recall the exact date.
Okay. And you started talking about this why did you start talking about this when you hadn't talked about it in your report that you provided?
Well, I mentioned the fact in my conclusion that I did not believe this to be premeditated based upon the fact.
But this is not what we're talking about. We're talking about what's instrumental and expressive.
Well, in order to explain how I came to that conclusion, I began to study more in depth the issues about homicide and types of murders, and I came up with this research, which I felt would be good for me to educate the jury.
And so you came up with this research involving premeditated murders, what you're talking about,
Yes.
right? And this helps explain what is a premeditated murder.
No, it explains why it is not a premeditated murder.
Okay. It talks about premeditated murder, right? And in your opinion, this explains why it is not a premeditated murder.
That is correct.
This issue, these terms, instrumental, where did you get them from?
Commonly from the literature, of which I've included several different.
I understand that, but if they're common, why didn't you use them in your report?
Well, because I wasn't planning for the defense. There's just a certain amount of time that you can put into every report. When they then prepare for a testimony, the further research is generally done.
All right. And as I understand it, instrumental is equated with premeditated.
That's correct.
And expressive is equated with non-premeditated murder.
Yes.
And you're prepared to discuss premeditated versus, and I know that the term is instrumental versus expressive, but I'm going to go with the other terms. And you're going to discuss premeditated versus non-premeditated murder.
If given the opportunity, yes.
Right. But that's what these two terms refer to, right?
Yes, that's exactly what they refer to.
And so one, for example, instrumental talks about what research has said is a premeditated murder.
Yes.
And the other one talks about what expressive being what is not a premeditated murder.
It correlates with certain characteristics and personality.
Right, but it talks about what is not a premeditated murder, right?
Part of the conversation, yes.
Right. And there's different types of crimes research that again goes to this issue of whether or not it's premeditated or not premeditated, correct?
Yes.
This dissociative amnesia, is that something that we talked about, is that associated with the PTSD that we talked about previously?
PTSD, correct.
Right. In other words, what are you talking about when you say dissociative amnesia, and how is that linked to this post-traumatic stress disorder issue?
It's related to her inability to recall the details of the crime.
Okay. And what is dissociative amnesia?
Dissociative amnesia is an amnesia caused by psychogenic factors. It can also be caused by some physical factors as well. But we know that a significant percentage of people who commit crimes, especially homicides, experience amnesia. And that's due to the intensity of the crime. In fact, people who experience trauma, a significant percentage will not remember the details of the trauma.
But in this case, you reached that opinion that she may have had amnesia. Is this a result of the testing, or is this a result of you talking to her? How did you reach this opinion? What steps did you take to say she has this dissociative amnesia?
Well, my testing revealed that she suffers from post-traumatic stress disorder.
What testing?
The Milan Clinical Multi-Axis Inventory and the post-traumatic stress scale.
There are no other tests that you've given?
No.
Okay. And those are the ones that indicate that to you that she has PTSD.
Well, I also compared her symptomatology with the diagnostic criteria from the DSM.
Correct. Is it DSM-4 or something, TR, or was that what it's called?
Yeah.
Okay. And then, so this right here, this amnesia, is something that's related to the post-traumatic stress disorder that you and I talked about previously.
Yes.
The stressed hippocampus, whatever that is. Hippocampus. Whatever that article, what is that about?
That explains how the memory capacity is distorted and actually will shut down under conditions of extreme stress, which I indicate she experienced during the commission of the crime.
And this stress that you say that she experienced, that's based on what she told you, or is there anything else that
Well, based upon the characteristics of the crime scene and what she told me.
Okay. This issue involving for example, the post-traumatic stress disorder, do you feel that you need the statement from the DSM-4 TR up there in order to explain what PTSD is?
Well, I didn't prepare a slide to that effect, but I
know you didn't. I
could.
But
I have the book. We could put it under.
Right, but what I'm saying is, in order to explain PTSD, you didn't prepare the slide, so you don't need it, is my point.
No, I can verbally describe the characteristics.
Well, what makes these other things that you have here, amnesia and crime dissociative amnesia and all of that, what makes that any different? I mean, obviously you could also describe that without resorting to the articles, correct?
Well, I'm bringing in material that may be unfamiliar to the jury.
I understand that, but you could explain it to them, right?
I could explain it to them.
Sure, just like you do with your ultimate opinion that she had PTSD, right?
Yes.
Okay. With regard to this Time magazine article, I mean, it's relatively new. I mean, January 20th of 2013, right?
Yeah.
And I mean, it's just anecdotal, isn't it? I mean,
Well, I mean, that's how it's presented. It's presented as an anecdotal presentation, basically to illustrate that this is a fairly common phenomenon, even by someone who's experienced in dealing with such types of stress. And then I was going to explain the physiological changes that occur in the brain when people are under stress and why memories are not formed as a result of that stress.
And I guess my point here, and my question to you is, you don't want in the article to say, well, there are many instances, and you can cite whatever instance you want involving X that indicate that under extreme stress, this is what happens. I mean, you don't need these Time magazine articles to explain that, do you?
Well, I've always found that in presenting data to a jury, it's easier to use audio-visual means when possible.
I understand that, but you can do it. I mean, you told us that PTSD, which is very complex, that you can explain that to them. What's so difficult about explaining the story, which is really what we have here, to the jury? I mean, this is a story about a cop or something. I didn't read it, but isn't that what it is?
Yes.
I mean, so what's so hard about explaining, what's so difficult about explaining a story involving a cop to the jury?
It's not difficult. It's just that we live in the 21st century. We have these methods available to us, and I believe strongly that when teaching students or teaching a jury, that it's better to have multimodal exposure.
Right, but you could do it, couldn't you? I mean, you could just get up there and say,
A blind person can run the bases too under certain conditions.
Sure,
You don't have to.
And we don't care about blind people, do we?
I do care about blind
You
people.
care about blind people as it applies to Jodi Arias?
I care about blind people.
What does a blind person have to do with Jodi Arias? Tell me about that.
Are you serious?
Yeah, you're the one who, did I bring it up or did you bring it up?
No.
Who brought it up? Let's get to that. Who brought it up, me or you?
I'm talking
Who
about...
brought it up, me or you? You're here to answer my question. I did bring it up. You said
Yes.
that even a blind person can run the bases, right?
But this is on tape.
Right. So that has nothing to do with this. I want us to get back to this case.
Go back to it.
Right.
I just used an example.
Right, and I'm saying that you can explain it. Can't you?
Yeah, I can explain it. I can explain it. Sure.
This is just a story that was of something that was published in Time magazine, right?
That is correct.
The same thing with the cross-section of the brain.
No, that's different.
Well, no, let me ask you the question. Are you medically trained?
I have a degree in biopsychology, and I have written 2 chapters in a book on brain training, which includes physiology. I have taught physiological psychology to undergraduates and graduate students over the years. I have taught medical students about the functioning of the brain. I am not a MD.
So do you have a medical degree? The answer is no.
No, of course not.
Okay.
PhD.
Okay, and with regard to this issue of the cross-section of the brain, it appears that you have some study involving that, right? And you're familiar with it, right?
No, I'm trying to explain to the jury who's under...
That's not my question. I'm talking about your experience and what your training is.
I'm answering it. I use that diagram whenever I lecture about the brain.
Okay. That's not what I'm asking you.
I'm afraid I don't understand.
Okay. You indicated that you have a lot of training and education involving this issue of the brain, right?
Yes.
And so you're conversant in that area, aren't you?
Yes.
And you've lectured on it, right?
Yes.
So you don't really need a brain up there to explain it to the jury. Because of all your training and how well versed you are, you can explain it, right?
A picture is worth 1,000 words.
I understand that, but can you
I can explain it without a picture.
That's all
without
I want to
shortchanging the jury.
I understand that that's your view, but you can. The issue is whether or not you can explain it.
I can.
Okay. I think I'm done with the interview. Thank you.
Before I hear argument, counsel, please approach. All right, oral argument on this motion, Mr. Nermi.
Judge, in addition to the record we just made in the record, and if I might, I would seek to move, and I believe I did before, Exhibit 1 that was just played for the court into evidence.
For purposes of this proceeding only, Mr. Martinez, any objection?
No.
Exhibit 1 will be admitted for purposes of this proceeding only.
What we heard moments ago as it related to the other misconduct motion was we heard, oh, the prosecutor can't be tied to anything. It was just some inadvertent, unscripted sideshow, if you will. But here what we have, what we've just played for the court, is Mr. Martinez interviewing Dr. Samuels before he testified, questioning, trying to assert or what I would more properly say is bully Dr. Samuels into presenting the evidence in the way that the state wanted the evidence to present. That sort of bullying is improper. The defense, the state doesn't get to decide how Ms. Arias presents its case. The fact that adversely probative evidence is going to come in and is to the state's disliking does not mean that the state, counsel for the state, is entitled to come in and bully Dr. Samuels about the way that he wishes to present the evidence, demonstrate the evidence, yelling at him, leaning forward, and it's not reflected in the tape, leaning forward, yelling at him about, well, you could present this without this, you could present this without that, because that's the way the state wanted the evidence presented. He's not in control of that. This, we heard out through the entire tape, how he wouldn't let Dr. Samuels answer questions. And then the coup de grace of misconduct, the epitome of it, if you will, starts yelling at Dr. Samuels about blind people and attacking him on whether or not he cares about blind people. And that there is no basis in reality for that. It is intimidating the witness. It is bullying. It did occur before Dr. Samuels testified. And that sort of behavior is improper. It can have impact on the testimony that Dr. Samuels gives, combined with all the other statements, and I want to be clear too, all the other things off the record regarding Dr. Samuels, that were in sealed proceedings, I should say, regarding Dr. Samuels, does show a pattern of witness intimidation engaged in by this prosecutor. And it is sufficient combined with everything else. And we're not talking about this in a vacuum. If this were in a vacuum, I probably wouldn't be here grabbing my pennies, as Mr. Martinez would say. But instead, this is a continuum of behavior, Judge, that began months before this case went to trial and has continued to date. The fact that we're 4 months into a trial cannot be relevant license for Mr. Martinez to say, I can do what I want because, you know, we're not going to declare a mistrial this far into the trial. Intimidating witness, bullying witnesses, as he did with both Ms. LaViolette and Dr. Samuels. And this occurred over defense objection, both in the courtroom and outside the courtroom. All grounds for prosecutorial misconduct and all grounds for mistrial, Your Honor.
Mr. Martinez.
Initially, I'll address the two witnesses, Alice LaViolette and Richard Samuels. An allegation that somehow the state was inappropriate in questioning Alice LaViolette. That was in sealed proceedings. You were present. You know the circumstances. Nothing could be further from the truth, and quite frankly, it is heartening to the prosecutor to have the defense attorney make that argument and to have you present so that you could rule on their objections as the questioning went along and you could see the subject matter that was being addressed. So clearly, there was no prosecutorial misconduct. If somehow there's this allegation that she was upset about it, well then she should be upset based on what was uncovered at that hearing. And I think the court knows what I'm talking about. In terms of Mr. Samuels, we need to step back and take a look at how that happened. First of all, there's an ethical issue with regard to the defendant. Or the defense attorneys, I can't really properly say it's the defendant. Defense counsel, on the eve of Mr. Samuels' testimony, had a PowerPoint. This PowerPoint had not been disclosed to the state, and had the state not walked by and seen the first slide, there would have been an issue as to this being shown to the jury before the prosecutor had a chance to look at it. There was no disclosure. There was a violation of the rules there. Not only was there a violation of the rules, but there's an attempt there to gain a strategic advantage. So you can't look at this and keep pointing the finger at the prosecutor and then say, well, what we did was unethical, but only look at what the prosecutor did. So let's look at what the prosecutor did. During the lunch period, he was given his opportunity to speak to this individual. We all know how long the lunch period is. We know that these have to go as quickly as possible so that we can get to the issues that are being raised. And one can only say, thank God that there was an audio of this so that the court can actually listen to the exchange between the prosecutor and Mr. Samuels. There's an issue involving whether or not there's this comment about blind people. The prosecutor didn't bring that up. It was Mr. Samuels, as the audio shows, who was trying to be evasive. We do have a limited amount of time here, and his being evasive was something that the prosecutor called him on. You can hear the tone of the prosecutor's voice, you can hear the tone of Mr. Samuels, and you could hear the tone of defense counsel in there. They were raising their voice higher than the prosecutor. I'm sure we can conduct a test to see. So this issue about blind people was raised by Mr. Samuels. They also say, well, this could have an impact on the witness's testimony. Well, we could have a solar eclipse today, but that's not something that has been proven that Mr. Samuels' testimony was impacted in any way. For example, his failure, if you will, with regard to the PDS would not have been changed in any way, shape, or fashion, however the tone of the prosecutor was. He just, quite frankly, relied on a lie, and he was questioned about it. So I think the state believes it's fatuous to say that his testimony could have been affected. Additionally, the motion raises some issues that attempts to make the state responsible for how conventional media and social media cover this case and how the individuals are portrayed. The state does not have any control over any of that, and I think it's something that defense counsel constantly keeps, if you will, attributing to the state. One example that I can give you where the state has no control over social media is the defendant. There's been allegations that she's been tweeting, I think is the word. I don't have any of that, so I'm not familiar with that, but I know that I've been told that she's been tweeting through, I guess it's an acquaintance of hers, a female acquaintance of hers, and there are things that have been going out. So if we're talking about the flames of interest by the media, whether it's conventional or social, in this case, they're being fanned by the defendant herself. One can't forget that she's a witness in this case, and she's actually violating the court's rule about discussing her testimony. So if we're going to be looking at that, and quite frankly, as I think of it now, I'm asking the court to issue an order that she desist from that because, again, she has testified, she is discussing her testimony, and again, if we're going to talk about disparaging comments that are made, again, I don't have an account, so I don't know the exact words. I don't watch television coverage of this particular trial because I just don't. But I've been told that she indicates something about the prosecutor and how tall he is. This is the type of conduct that they're complaining the prosecutor is doing, but when you take a look at it, it's actually created by the defendant. And I've gone at length to go over that because there is this constant attack on the prosecutor about his conduct, about what the media says about him. What the media and the people out there choose to believe is up to them. I have no control over it, and it appears, however, that the defendant does have control and seems to be attempting to manipulate it. So I have my written response. I think it addresses the court's issues or the defendant's issues, and I ask the court to deny the defendant's request again for another mistrial. Thank you.
Your Honor, I'm sure the court's at least somewhat familiar with the shell game, right? You take the ball, you put it around, and you shuffle all the hats around, and you look for the ball under the hat. You change the game, you change the rules, you change the argument, right? And this is what has happened. with the state throughout the proceedings this morning in regards to defending himself from prosecutorial misconduct. He says, well, Ms. Arias has a Twitter account, so there. Okay, well, that's not really a responsive argument, is it? And he said he doesn't have any evidence of this. He's just going to point it out and say, I didn't commit misconduct because she has a Twitter account. Okay, this isn't second grade. This is a court of law, and it should be treated as such. This trial is not just being tried in this courtroom. It is being tried everywhere. And again, I talked about the fantasy land of this jury not hearing these proceedings. But what he does, the prosecutor does and says, does affect the surroundings and the behavior outside the courtroom. But we don't even have to go that far. In terms of this shell game that he is playing with the reality here. We've talked about Ms. Wilmot provided him the opportunity to look at the PowerPoint before they went on the stand, before Dr. Samuels went on the stand. It was created like the evening before. He had a chance to look at it, and he claims, well, it's just because I walked by. You know, referring to Dr. Samuels as Mr. Samuels is further evidence of misconduct and the disrespect and bullying behavior he's showing towards witnesses. The man is a PhD, he's a diplomat, and he consistently tries to degrade him by calling him Mr. Samuels, stooping to levels that, fortunately, I guess for him, that the defense will not stoop. So, regardless of Ms. Arias' Twitter accounts and comments on his heights or whatever he wants to attribute to her, it does not change the game. You have to keep the eye on the ball, Judge. We're not talking about blind people. We're not talking about dogs. We're not talking about anything else but Twitter accounts or whose Twitter account. But we're talking about the misconduct of this prosecutor and the witness intimidation that he is engaged in with both Ms. LaViolette. And I am glad the court was there for the proceedings because and sealed and otherwise because it knows the extent of the intimidation that Ms. LaViolette felt, knows the extent of the intimidation that was imposed upon Dr. Samuels, and heard it from the prosecutor's own mouth in this tape yelling him about blind people. This is misconduct that has nothing to do with anybody else's Twitter accounts or anything else. Pointing the finger back the other way does not absolve the state of its responsibilities.
All right, this court recognizes there can be a fine line between zealous advocacy and unprofessional or unethical conduct. In this case, the two situations being argued as a basis for this court finding prosecutorial misconduct both occurred outside the presence of the jury. This court has no evidence that either of these events or situations affected the testimony of either of the witnesses, meaning Ms. LaViolette or Dr. Samuels. Again, mistrial is a remedy for trial error. The court finds the defense has not established that there was any trial error because of these events, and the court finds that there is no basis for mistrial based upon these two situations. Furthermore, this court finds that the prosecutor was not in any way outside the bounds of proper behavior during the in-chamber sealed discussion with Ms. LaViolette. I find there was a legitimate basis for the questions being asked during that hearing. With regard to the interview, again, the court has no basis for finding that Dr. Samuels' testimony was affected in any way by anything that was said during that interview. With regard to the state's request that the court enter an order regarding the defendant tweeting from jail, I have no information about that situation. Mr. Nurmi, do you want to be heard on that request?
Your Honor, if the counsel for the state wishes to cease any behavior that he alleges to Ms. Arias, I believe the proper course of action would be to put a motion in writing, see why he believes she's violating any orders of this court or any rules. I don't understand what the correlation might be. So she has freedom of speech rights, as does anyone else. So I don't understand even the assertion. I see it as a way to deflect this court's attention from his conduct, but be that as it may, if he wants her to cease a particular behavior that he's attributing to her, I believe he would have to come forward with some evidence that it's her, and he would need to come forth with some sort of legal argument as to why it would be improper.
Mr. Martinez, do you have anything else that you want to present on that issue at this time?
It's something that our office has discussed. However, we do not want to be accused of prosecutorial misconduct for conducting an investigation. I know that it has been brought to my attention by my office that this is happening and that I should bring it to the court's attention and ask you what I just asked you. The idea of conducting an investigation on this issue creates, again, the situation where the state is put in a position where it then is accused of somehow attempting to intimidate the defendant. We do not want to be accused of any of that in any way, shape, or form, but we have received information, and that's the information that she is tweeting through. I think the name is Devana. I think it may be Donovan Barron, something like that. I don't know the name. I didn't bring it with me, so that's all I have. We have not done anything other than view what the media has out there.
All right, well, without more specific information regarding the allegation, this court is not going to take any action with regard to the defendant allegedly tweeting from jail. I believe she is in the custody of the sheriff's office, and that is within their jurisdiction to set rules and limits with regard to her behavior in that regard. If there is something more specific that you believe is affecting the trial, I will certainly take that request into consideration. All right, with regard to the testimony of the witness, as I said, I do want to do some additional research on the issue under Rule 702. It is a few minutes after 12. We do have a 1:15 sealed proceeding with Ms. LaViolette, so at that time I will issue my ruling with regard to Mr. Neumeister.
Actually, if we could proceed, approach the bench ex parte just for a minute.
Certainly. We are in recess until 1:15. Please be seated. The record will show the presence of the jury, the defendant, and all counsel. Good afternoon, ladies and gentlemen. Thank you so much for your patience with us, as always. The parties have reached a stipulation or an agreement. That stipulation is as follows. Ms. Arias was not holding a knife or gun in her hands when exhibit number 159 was taken. Exhibit 159 is on the screen in front of you. That photograph was taken on June 4th, 2008 at 5:29:20. Does anyone need me to repeat the stipulation? I see no hands. All right, ladies and gentlemen, I have some good news or bad news depending on your state of mind. That is all we have for you today. So we will see you back here tomorrow at 9:30 a.m. So tomorrow morning, 9:30 a.m., please remember the admonition. You are excused.
Please stand for the jury.
Record will show the jury has left the courtroom. Counsel, anything else for today?
Will we establish a time for tomorrow morning?
9:30. Anything else?
No, thank you.
All right, thank you. We're at recess.